maintenance, financial stuff, and useful information that I haven't written down the topic, so I'm firing along already. And I warned Guy that when I turn up to these sorts of things, I'm more of a big picture person, so I didn't necessarily print out his, bio. So he's given me some information, but he hasn't given me a lot. So I'm going to share with you 3 things I didn't know about Guy before tonight. I learned that he was admitted to the bar in 1993, but he wouldn't disclose to me when he became a solicitor. So in 1993, I thought you might be interested to know that Paul Keating won an unbeatable election. TV show A Country Practice was cancelled. And Sydney won an Olympic bid, and Guy became a barrister. And then I asked Guy what he would be doing if he wasn't a very talented barrister in family law, and he told me he'd be at the beach. So I assumed that he's a surfer. I tried to learn more about that, but I haven't learned too much about that, other than his first overseas holiday was in Bali. And that he walked the Dakota Trail in 2005. So I've learned a bit about Guy tonight without bringing his bio. And I'd like to welcome him, and I'd also like to thank you for taking the time in presenting for us tonight. We really appreciate it. So if I can hand over to the serious part of the evening. Thank you.
Thanks very much, and thanks for coming this evening. This is a hard act to follow. We'll try and get on to the topics that we've got, and I suppose central to what we're discussing tonight is the overriding or overarching issue there is in financial matters. That is the obligation on parties to make full and frank disclosure.
We left it too long.
So here come the prompt. The first matter I'm going to speak about is a case of Luciano that you may have heard of, Ryan J. Back in the early 2000s, and he makes a very sort of cogent statement in relation to the obligations of parties to make full and frank disclosure in financial matters, and it applies to all matters. And that was it's overriding. What's described by the rules of court is not the beginning and end of what a party's obligations are. So for a party to say, well, if I've complied with the rules, be they the Federal Circuit Court rules or the family law rules in relation to disclosure, is not sufficient. Any documents that are relevant to the matter that's an issue have to be disclosed.
I can't find the app score. Can anyone show me the Guy will now do a small tap dance.
Yeah,
Just a bit there. Shift. Try that.
Now we'll go to Luciano, and in relation to that case, you can see Ryan J summarised the principles, and in looking at the core points he makes, dot point 4, if there's a deficiency in the practice adopted for the purpose of making such a disclosure, mere compliance with the requirements of the relevant rules, if deficient, is simply not enough. And if there is non-disclosure, stating once again the obvious, the failure to disclose undermines the whole process of adjudication of the proceedings in relation to financial matters. And a finding of non-disclosure in a financial matter can have fairly drastic consequences for the party that has non-disclosed. But I'll deal with that in a bit more detail later. But just going forward, the relevant rules in the family court in relation to disclosure is set out in Rule 13.04, and the equivalent rules in the Federal Magistrates Court, Federal Circuit Court now set out in Order 2024, I think, .03. Now, in dealing with the issues of full and frank disclosure. I've done a summary of dot points in relation to the matters that should be taken into account. So keep going, yeah. And thank you. In looking at the other party's material, affidavit, financial statement, in preparing a response, it's important to look at the allegations that are made, and particularly in relation to the financial statement, establish the evidence that's required, the disclosures that's required to prove the point that's being made, and for that matter to disprove what material is there in your client's case to disprove what the other party is saying. And it's a process of really testing sort of what you see in the other party's material, whether it's in admissible form, whether it's a bare assertion in relation to a value of an item, and keeping in mind disclosure and its importance in advancing your case, and obviously attacking the other side's case. Arrange disclosure at the earliest opportunity. If there's been no disclosure in pre-action procedures, if you're in the family court or in the Federal Circuit Court, make the request for the documents that are relevant under the relevant rules, and identify any other documents that you think are specifically relevant to your case. Now, it's also important in the process of, if you're involved in a court process, if the documents aren't obtained, put the other side on notice that you'll make an application for disclosure of those documents, and by a process of putting pressure on your opponent, you'll find yourself in a position of, when you get to the first return date, if there are classes of documents that you haven't received, put that in your application in a case of another discrete order to obtain. Usually what will happen, you'll get most of the documents. So by the time you get to the first court date, you've got a working idea of what your opponent's saying. Now, the other matter that I think is worth considering in the interim applications, interim property, interim spousal maintenance applications, is what documents are you not going to obtain from the other side that you need and you consider relevant to presenting your case. And quite often in cases there's been advances being made to one or both parties during the course of the relationship. Let's say it's the husband, the situation of the husband being in control of business, corporate structures, has been borrowing. Now, the statement of assets and liabilities that's being presented to the bank, diary note entries that appear on a bank file, they're not going to be in the possession of the other party, or perhaps not even in their control. So quite often subpoenaing the bank records, be it bank records in relation to statements of assets and liabilities, or in relation to accounts that you believe haven't been disclosed and you have evidence that they do exist. That's a good device in getting the material you need to advance your client's case before the first return date. Also, it comes up in relation to whether a case where disclosures are really a real live issue as to how a party is funding their legal fees, and I'll come to a case later on in relation to where that occurred. And it's not uncommon for solicitors to subpoena their opponent's trust account ledger record to ascertain how they're being funded. Where are the monies coming from? Are they coming from an account that hasn't been disclosed in the possession or control of the other party? Do do they have a benefactor that's paying the legal bills, or however else they may be funding their fees. Now that's obviously relevant for the sake of knowing how they're doing it, but it's also relevant in a case where you're acting for the party who doesn't have the capacity to fund their solicitor's fees. And I'll come to that once we will move through this part, but just to indicate that there's authority for the proposition that for every dollar one party pays their lawyer, they have to pay the equivalent to the other side, and that's a mechanism. It's not perfect, and I'll come to it in a bit of detail later in one of the cases that I'll be talking about tonight. But at the very least, where there's no fund of money that can be made available, or property that can be sold to fund the fees, that is a useful device, and probably one I'd recommend that you use as an alternative relief if you can't identify a fund of money, a source of money, or a source of income, if there's business involved, where those funds can be paid from. Now, it's interesting in looking at the rules that you're no doubt familiar with in relation to a spousal maintenance application, an interim spousal maintenance application, and you've just got up there now the family law rules. On the first return date, each party must bring to court the following documents: 3 years of tax returns, bank records, taxation records, etc. And also, as part of the rules, the subparagraph 2, before the hearing date, a party must produce the documents referred to in subrule 1 for inspection if the other party makes that request, and that's to be done within 7 days. So there's another valuable sort of tool where the spousal maintenance application connects with the other interim relief in obtaining documents. Okay, so now we'll have a look at the Federal Circuit Court rule, Rule 24.05, which seems to be certainly on one reading in favour of the applicant. It's only the respondent that has to bring the relevant documentation, and on a much more limited time frame. So if you're acting for the applicant, you're acting for the respondent in the proceedings. Once you've been served with the application, there's nothing to preclude you seeking disclosure from the other side. But certainly be aware of this rule when acting for a respondent of the respondent's obligation to have those documents at the first return date. Now, really sort of a crucial document in financial matters is the financial statement. It's a document that sort of quite often you're left with the impression, or not more than an impression, that a lot of attention hasn't gone into it. So, and I imagine that's an experience you've all had at some time. And it's a document that a lot of care has to be taken. It's got to be in the sense of if there's a few glaring areas and matters that the opposition is going to grab with both hands, particularly in a interim spousal maintenance application, if there is the opportunity for cross-examination, it can sort of put your client, if there's a lingering impression that he hasn't made full disclosure, or is otherwise muddied the waters in what he or she has put in that document. So it's a very important document to get right at the commencement of the proceedings. And as part of that, it's important to tell your client at the earliest opportunity in a financial matter what his or her obligations are. And probably to go to the extent, and you can tell me whether you do or don't at the present time, give them a copy of the relevant rules in relation to their obligation. Now, you may or may not do that, but I would, in being mindful of your own obligations as practitioners in relation to your client, the conflicts that can occur, if potential conflicts occur, if your client is not being compliant in relation to making full and frank disclosure of his financial position. The financial statement on the face of it casts a very clear obligation on legal representatives to have made clear to their clients their obligations, and probably to protect yourself, giving them a copy of that of the relevant rules, so that there's no question that they haven't complied with it. And maybe at some point in initial correspondence, sending them a copy of the relevant rules so that there can be no assertion made later by a client in the witness box, oh, I didn't know about that, and the solicitor didn't tell me about that. Which can happen with clients when they're caught out. Who do they blame? They blame the lawyer. Sometimes the barrister. Okay, so something to bear in mind, I think. And in looking at the financial statement, if you've got a copy of the financial statement that's been handed out. I think the first point is, which we've already covered in relation to explaining to your client his or her obligation, is to give the document, and I'm sure you do, because you don't want to have to do it yourself or be anywhere near it most of the time, give them a draft to take away. And explain to them the process of what they've got to do, and I'm sure for a lot of people it's like a tax return. They find it complicated. So walk them through it, and so that you get the most accurate information in the document, have them sign the payslip, the superannuation statement, the rent slip, the bank statements that show what their current balances are, their mortgage statement. So that wherever you can in completing the document, you have the right figure. And where you can't do that, and it's got to be an estimate, it's got to be an estimate. But wherever you can, have the most accurate information. And in going through the form that you've got there, this is one that I've seen previously, and there's another one I'll speak to briefly that I saw last week. But here you've got a document, the financial summary. You've got a figure, 2,815.02. So you'd assume that's taken off a document to have the cents there. You'd assume that's accurate. Then you look at the expenditure, $3,515.67 a week. Once again, first blush, you think that was an accurate figure, but down to the last cent. On that basis, if those figures are accurate for the purposes of the discussion, there's a shortfall of expenses over income of some $700.65 per week. Whenever you see a surplus of expenses over income, particularly in maintenance cases, but you're looking for where's the source of that shortfall? How's that shortfall being met? Is it being met by a drawdown of capital? Is it being met by a credit card? Is it being met by a third-party loan? Is it being a tin of cash in the backyard? It's a question you should ask because on the face of the document, you're not going to usually find the answer. And when you go back to the relevant rules in relation to financial statements, in effect, you're under an obligation where the financial statement doesn't tell the story. You should be explaining the balance of your financial position in an affidavit. And also be mindful of the obligations under both rules in relation to amending your financial statements if there's a significant change in the relevant information. Now back to this document. You go over the page. You've got the note in relation to putting the weekly amounts in dollars. If the amount for an item is nil, write nil, and you can look at the blanks on the page. So you've got to fill in each part of the document. In looking at the income of the party, the income that's in items 9, 10, 11, that corresponds with what is on the first page. And then when you go over to the Part E, once again, other income earners in your household, it's left blank. Now, blank code for, well, too late to fill it in properly or don't want to commit. So your clients leave themselves open if they don't fill in every part. Then the other matter that could be relevant in this case, expenses paid by others for your benefit, left blank. And that's one of the things that you'll probably be thinking of as you go through this document. Well, how's the short? We've got a $700 shortfall to start with. How's that being met? Not getting much help from the document the way it's been completed. Then when you look at the personal expenditure on Part G, once again, there's not a nil or an estimate where it may be required. Going over the page to the end of the personal expenditure, I've subtotaled down to item 31. That comes out to $1,411. And then 32, which I think is a bit of a trap for a lot of people, because you see, I'm not suggesting anyone here, but you see a lot of financial statements of financial circumstance where it's left blank. Because I think some people think, well, it doesn't apply to me because there's no spousal maintenance application on it. But that is the box where you put the balance of someone's living expense. And those are the expenses, and the guide to what those expenses entail is contained in Part N, which you fill in relation to maintenance proceedings. So in this case, it has been filled in, and the figure that's been put in there is $1,789.67. Now, in trying to find a guide as to where that figure's come from, if you go over to Part N, you'll see that the party has set out $4,237 of weekly expenses, made up of $1,894 for the deponent and $2,300 odd for the children. When you go back to item 32, it's a different figure. So whether that's just a slip and it's the same figure that hasn't been carried across in error, or the figure of $1,789.67 represents something else, we just don't know on the face of the document. But what it does tell you is that the actual expenses that should be on page 1 comprised the 4,237 and when you do the adjustment, on the figures, and even allowing for the 1789.67 being just a flip of the pen and being in fact representative of the figure on the back page, you have weekly expenses of just in excess of $6,000. Now that's on the face of the document you're reading. So the figure that should go in Part B, just on reading the document, is something in just over $6,000. And that's something that's over double what the disclosed weekly income is. So that should be setting off some alarm bells. And where's the explanation? How's that shortfall on the face of this sworn document being met? So their questions you'd want to be asking the other side. And if you wanted to ask them to disclose the document support, what their financial statement demonstrates on the face of it. I can keep talking. No interruption. We keep going through this document. Item 11. Income from a family trust, $289.50. If we go over to item 41, you'll see interest in a business, and it's income of $15,000 odd shade a year. So in item 11, we've had the income distribution from the trust, and over in the asset side of the document in item 41, we've had it repeated. So once again, there's been not once again, but in that particular case, there's been a confusion as to income and capital. So the value of the trust, what the actual underlying value of the trust, has not been displayed in the document. And obviously that'll be a matter for valuation at some later point in time. There are other glaring errors in the document. Probably the only other one worth referring to is item 35, home, name of the registered proprietor, just left blank. But interestingly, in item 36, there's another property referred to, and the value is put at $449. And this is a real document. If you go over to it's been changed, of course. It's got a lot of allusions to Harry Potter, courtesy of my secretary. But if we go over to the mortgage liability, there's a mortgage, I think, in the order of some $300,000 over that property that has a value of $449. So all I'm just trying to demonstrate by this document, I'll go quickly to another one, is that it happens quite often that you get documents that haven't been filled in properly, and it provides a bit of a war chest going forward if you have the opportunity to cross-examine a party about this sort of document. And it's amazing how people have come and said, yes, I read all that, read that, I checked it, it's true and correct, etc., etc. And then you can go from there and sort of deconstruct their case. So I'm just trying to highlight, and with the checklist that you'll all get a copy of, just the care that you need to go to in relation to the completion of the financial document and how it's a pivotal document. It's central to a financial case. It's central that you get it right the first time, and you can't have and you don't leave your client open to having inferences drawn by your opponent, allegations made that that your client is being non-compliant with his obligations, or in the docket system having a client that seems to sort of create oppression on the first return date. So I'll just move quickly to yeah. Sure. It could be a separate item and a weekly amount, or if legal fees have been borrowed from a family member or litigation fund, you disclose it in the finance. It's a liability if you've borrowed the money or you owe a third party the money. And can I just say that there was a debt in this one too, but the fact that there is an assertion in the financial statement that the opponent owes $22,000, once again, that's meaningless. It's in a vacuum. Once again, the affidavit should cover that loan by setting out the circumstances of when the loan was made, whether it was anything to in writing, whether it was interest applicable, the whole factual background to test its authenticity needs to be set out in an affidavit, filed at the same time as that financial statement. No other questions? Okay. I had another matter just recently in another court, and happened to be the wife. She stated her income, call it $530 a week. All the boxes have been filled in. Everything's sort of got a nil or a not applicable, that's all great. When you looked at the other income earners in the household, nil. Expenses paid by others for your benefit, nil. It's a terrific document. Personal expenditure, first superannuation payment, and it happens to be about 10% of the income disclosed on page 1. So something that sort of you see quite often. It's the contribution-based superannuation contribution paid by the employer that's been put in as an expense when it's not. It's not obviously not. So on the face of this document, I think it's safe to say that the payment doesn't have an expense. Now, when you get to item 32, which as I've already said, that's often missed in preparation of these documents, particularly I think where parties think that, well, there's no risk of a maintenance application, so I don't have to fill it in. But as you all know, in sort of the overall consideration of a property settlement, 75(2), respective financial circumstances of the parties, income, expenses, it's going to be relevant to some extent. So it's filled in, once again, sort of, there's an extra tick with paragraph 32 or item 32 being filled in at nil. Everything else has been filled in. There's some money in the bank, but there's no explanation as to how that party is meeting their expenses, and there's no affidavit. This party has managed to avoid filing anything more than a cursory affidavit with name, rank and serial number for some reason at the present time, notwithstanding the protests of my solicitor. But the interesting thing that came out of this hearing the other day, I only advised on because it was in another registry. It was foreshadowed that the wife's going to bring an application for spousal maintenance because she's been injured and her income's reduced. Well, there's a lot of getting past this guy. To be fair, the solicitors have changed, but acting for this party, but there's a lot of getting past this document. It's it's how do you get past it? She's affirmed or sworn to having read the relevant rules. She's made aware of her obligations, made full and frank disclosure. So once again, just another example. So I think I can get off financial statements now unless there's any more questions. Now, if we can move along to maintenance, interim spousal maintenance applications. You're aware of the relevant sections. Seen through the rules. There's a case of knowing and knowing, which I've referred to in my outline. And in this case, it was on one view of the pool. The husband was continuous worth about 538,000 odd. The wife was continuous with 10 million. So the usual sort of story, I suppose, at that level. This matter came before Justice Kent. I'll just digress for a moment because the case is quite interesting on a number of levels. In this case, the wife had some 66 separate or interlocutory or interim orders sought. And in managing the case, his Honour, within the family court, his Honour referred to Rule 5.10 and the 2-hour rule. And he approached the case on the basis of, well, you'll have to come back another day on the duty list. I'll allow 2 hours for the hearing, no evidence, just submission, plus reading the material, which was very, very generous in that context of the 2-hour rule. And he made determinations in relation to delegation of funding and at this point, spousal maintenance claim of the wife. Now, in this case, the amount sought was a significant amount, over $3,000. The wife obtained an order for just over $2,000, and his Honour, in his judgment, in dealing with the issue of spousal maintenance, provided a very useful summary of the relevant law and statutory law and the principles applied. And something that really came out of that case that explained the quantum of the maintenance sought. The husband wasn't really making any issue as to the amount of her need. He was making an issue in relation to her earning capacity, and that was ultimately taken into account. Any money the wife did earn from working would be deducted from the weekly amount. And the other matter that was argued strongly in the husband's case, that she was in a de facto relationship, and therefore the de facto should be sharing the burden or being responsible for her support. And that de facto relationship has been existed for some 4 years. So you think the husband on one level was on strong ground there. But it was found that the de facto could just support himself. So he had no surplus income to contribute to the support of the wife. So it shifted back to the husband. That was taking into account section 75(2)(m) and section 75(2)(a). But the other matter that was probably significant in that case, in the sense of the ultimate result, was that there was a corporate entity making significant cash stream. The husband was living out of it. The wife had been living out of it, and the order was the payment that came from that corporate entity to the wife. So that's probably. Any questions in relation to interim spousal maintenance? statutory principles or the law. Pretty well known to all of you, I'm sure. Section 77, urgent spousal maintenance cases. There's I've got a heading in relation to relevant cases. They go back some way. They were reviewed again in the case I've got on the list there, Hirsch and Searle, before Judge Scarlett, and most of the law is back within that time zone or earlier. The party has to be in immediate need, and a colleague just told me recently of a case that was in the middle of a call over, parenting matters on foot. The wife or her legal representative said my client's got no money, no means of support. So the next question was addressed to the husband or his legal representative: how much money have you got in the bank? $10,000. Or it was made almost on the spot. The $10,000 was handed to the wife on interim of urgent maintenance to be reviewed at a later point in time. So that's, I suppose, how immediate it can be. But I suppose in the reality of today's list and the delays there are on getting on, you can file an application for injunction and not have time of bridge to avoid what will happen if you don't get the injunction in a timely matter. So as to its relevance now, unless the relevance is on the day, or it becomes an immediate need on the day because of a set of unfortunate circumstances, that's probably all I can say about that at this stage. Dropped out again. Now we can move on to perhaps the interim property, interim property / interim costs, and also add to that the power under Section 74 to make a litigation funding order under that head, the maintenance head as well. Now, in dealing with this part of my paper, I'll refer to a case. It's relevant in respect of a number of issues, and it's the next case on the Strawn. You're familiar with Strawn, and the approach taken there. An appeal by the wife, who had been awarded $1 million towards funding her lawyers. Quite a lot of that money went back to paying previous bills, so in effect she only had about $300,000. The law essentially prior to Strawn had been a case, 93 case or thereabouts of Harris. For the court to embark on making an interim property order, you have to demonstrate some compelling circumstances. And that's where the wife was ultimately left at first instance $1 million, not enough to go around. She'd already spent, I think, at that stage something like $10 million. The pool was reputed to be $100 million or 80 million, something fairly substantial. The husband had remained in control of all the business assets and was pulling all the strings. And the full court in Strawn awarded the wife the $5 million she was looking for in the first place, clearly recognising that the wife's ability to litigate and develop and follow the disclosure issues that were outstanding was going to be severely impeded without that payment being made. I'll come to that as it has been dealt with in another case shortly. So if we go to the next case on that list. And this is a case that I had some brief involvement in after these orders were made, and I can tell you why it's relatively brief sort of shortly. But, this was a case where disclosure was, non-disclosure I should say, was alive and well. And it was the critical issue that then Federal Magistrate Hughes had to grapple with. As identified by His Honour, a significant issue in the proceedings is the husband's failure to make adequate financial disclosure and what inferences might reasonably be drawn about his capacity in those circumstances. And this was a case where the husband, together with his parents, had a partnership, a trust, and companies, and quite a tangled web of financial entities, and so complicated in fact that he couldn't file a financial statement. He managed to get some scraps together, some financial statements and so forth, but he didn't file a financial statement. Until his wife had left him, things had travelled quite well on this rural property, but that all that had fallen in a heap, or things had gone south since she separated. Now, in the course of argument, in dealing with the financial disclosure of the husband, His Honour observed the husband has not filed a financial statement setting out his personal financial circumstances. His counsel acknowledged his client had an obligation to file the document, but argued it was virtually impossible for him to do so because his personal financial situation was inextricably interwoven with the business. That's why. He argued that the husband should be criticised for failing to file the document, should not be criticised, I should say, for failing to file the document because the information could not reasonably be presented in the format provided in the standard form, so failure of form. In any event, the information would be no different to the information he had provided in relation to the business. His Honour's response was, I reject that argument. That comes as no surprise, but it goes on. The husband's evidence about the business is neither comprehensive nor clear. On the contrary, it was vague and incomplete. And then His Honour detailed the discrepancies he observed in the husband's case. And then later on, his counsel, who made valiant efforts to convince His Honour otherwise, counsel the husband submitted that the husband's personal financial circumstances do not fit neatly into the boxes provided in the standard form financial statement. Once again, another failure of the document. But bear in mind that the affidavit to overcome that. And His Honour addressed that. And then His Honour went on to find nowhere in all of the documentation filed in the proceedings is there any evidence of the husband's personal financial situation. At no stage did the husband say that his personal income and assets are limited to those disclosed in his evidence about the business entity. And then his counsel, as His Honour gets out later in the course of the judgment, counsel the husband made a number of bold submissions about the husband's failure to provide the evidence of his personal financial circumstances. He said the wife is well aware that the family has been supported over the years by the businesses, and she makes no suggestion that the husband has any personal income or assets from which he could satisfy an order for spouse maintenance. Well, it's really a sort of a case of catch me if you can on that basis, and once again, his honour rejected that argument, and went on to say, although the wife bears the onus of proving the husband has capacity to satisfy any order made, the husband has an obligation to make full financial disclosure in order that his capacity may be assessed. He failed to do so. And then the question of monies in a trust account came up, the legal fees. And His Honour went on to say, early in the proceedings, counsel of the husband was asked by the court whether his solicitors had money in trust for the husband's fees. Counsel advised that 2 payments totalling $18,000 had been paid into the solicitor's trust account over the preceding week. Once again, triggers on what we've already discussed tonight. There's been a change in financial circumstances. That has to be put on an affidavit or an amended financial statement. And then the solicitors on the other side had issued a subpoena against the husband's solicitors, and it came to light that over a period of 2 months there'd been $47,000 paid into his solicitor's trust account. This is the husband saying he's got no financial capacity to meet a spousal maintenance order. Once again, his counsel submitted that it would be wrong to assume that the husband has the capacity to pay spouse maintenance simply because those amounts were paid into trust. He said there was no basis to conclude the husband had access to financial resources. And then His Honour went on to refer to the case of Weir, a well-known case in relation to non-disclosure and authority for the approach that where a party is found wanting in relation to disclosure, the court won't be unduly cautious about making findings in favour of the innocent party, in this case the wife. The husband His Honour had no difficulty in finding that the wife was in need, and in looking at the husband's capacity, he referred to some of the snippets of financial disclosure that had been made that supported he had a cash flow. He pointed to the husband's failure to make full disclosure, and then looked at the evidence that supported he could find a capacity to fund his lawyers to the best part of $50,000 in that 2-month period. The husband gave no explanation as to how the legal fees were paid. His Honour inferred paid from drawings, paid from the business, paid by the business, paid by a loan, paid by a third party. And in the absence of evidence to the contrary, His Honour quite properly found that those resources remained available to him. Now, His Honour had to be pretty creative in relation to the payment of the school fees by way of an interim property order, but he found a way to do that. And in relation to the litigation funding order, apart from the playing field being levelled by the payment being made to the wife of $47,000 to bring things up to date in relation to the amount that the husband had paid his lawyers or had been paid on his behalf, His Honour made a dollar-for-dollar order. Now, in looking at the orders that were made by His Honour, just go back one second. That's starting that back. Thank you. He made the order for the payment of the $47,000. I can't say whether that was paid, but that's when I became involved and it hadn't been paid. In relation to the balance of the way that order's been structured, there's no way around. If he's going to pay $1 to his lawyer, he's got to pay $1 to the wife's lawyer. So what ultimately happened in that case, I don't know. It'd be interesting to follow it up. But that was sort of created lockdown in relation to the husband paying his lawyers. He wasn't paying. He couldn't do it unless he paid the wife. I had another case where that order's been made once it had the same effect. I think the husband then declared himself bankrupt. So it's not top shelf. It's not a top shelf option, but it is an option in the alternative because it just shuts down the other side. So you've got the validation while you've shut them down, but the whole case shuts down. So you still have to proceed and do the best, do what you can, but you're not being paid. But the order, so I still think it's a great option, but it's the second one because you want an order in the interim litigation funding where the money's being made available. No doubt about that. And I'll go to knowing in relation, allowing I should say, in relation to that one. If we can just bring that one up. Thank you. Once again, this is this is part of one of the other aspects of the decision. One of the 66 items that Justice Kent dealt with in this case, and His Honour, as he did with the statutory and legal authorities in relation to interim spousal maintenance, did likewise in relation to the litigation funding order he made in this case. And I commend you have a read of the case when you have the opportunity. But His Honour, in dealing with this aspect of the case, readily found that it was a case that fell within Strawn's case, and those circumstances included the following. Self-evidently, there was a significant complexity in relation to the financial affairs of the party. It was appropriate in order to adjust between the parties. They each had access to capable legal representation, accounting expertise in assuring their competing claims. And I've already indicated, husband says $540,000 pool, and wife intends $10 million. Now, His Honour didn't quite give what the wife was looking for. He in the lump sum amount, but he enabled both parties to draw down a line of credit to the extent of $20,000 a month to fund their respective campaigns, pending the sale of the property that agreed to sell, in respect of which they were each going to take a third of the proceeds. At this point, how are we going for time? Nearly there? Is there anything else you'd like me to address specifically out of what I've spoken about so far, or any questions? Sure. Add-back's still discretionary. Well, some people say there are no such thing as add-backs, but add-backs are still there. But and this is the case of 7 where it's addressed. But it's still, I think it's still a work in progress. I don't think it's necessarily a matter if you got to 50,000, you're just going to go straight back in. That's probably never been the case. Sean and Hopkins made a pretty Murphy's decision in Justice Murphy and Sean and Hopkins. You know, parties when they separate, they're not supposed to live at subsistence level. They can, in appropriate circumstances, draw down capital if they have to meet their reasonable living expenses. Ultimately, it's a question of what's reasonable. And there's also the issue of it's really a matter of just looking at what the money was used for. For example, you have a case, parties sell a property, they take $100,000 each out of it. Well, if they've taken the $100,000 out of it, it may be that it doesn't come in, depending on what they've done with it. But even legal costs may go back in, may not go back in. It's hard to give a concluded view on that, and you've got it's a case-by-case basis. It's not ruled out, but it's somehow different. I think everyone's sort of trying to get their heads around.
Can you please remind us what size of the school was?
Well, it was somewhere between 538 on the husband's case, something like 10 million on the wife case, which is not an unusual sort of scenario, is it? Sort of husband's in control of everything, it's worth nothing. Wife's been there for 28 years, 4 children, and made significant contributions in this case, and suddenly it's nothing. But the accounts they'll be having a field day.
Any other questions? Guy, can I thank you very much? Can we all thank Guy very much for his time and for making what is sometimes a uninteresting topic interesting. So thank you. Strachan is one of my favourite cases, and those of you that know me know that I'm not someone that likes cases. But if you've got nothing better to do with your time, that case is worth a read. It is fascinating. It's not one that'll put you to sleep. You will be sitting there with popcorn going, wow, how can people spend this sort of money? It's insane. And I think her application and the one that you were talking about was for $5 million to do the next stage of her legal process. And I think at some point she'd already spent $14 million on that. Like it's interesting.
And Strawn also, it's a case well worth reading.
And I think there's about 20 decisions in it too. So good luck finding the right one.
And there's some very well, and it's interesting just to sort of develop that as because there's reference to a case of Judge Berrigan in the New South Wales Supreme Court, and no doubt outright doesn't look like it. But certainly he's had some interesting judgments that have been quoted in many cases in the family court jurisdiction in relation to weights to give to initial contributions. So any of his decisions are well worth a read. And his decision in Paris King Investments gets quite a bit of airplay in the course of the Strawn judgment. And it's certainly not and it's interesting in his approach. Just to, I should say something a little bit more about this.
Of course you can.
Where there's been an order, where there's an order for interim litigation expenses, he sets out some fairly clear guidelines that have been carried forward and says there are at least 3 requirements. Firstly, the position of relative financial strength by the respondent, usually the husband. Secondly, a capacity on the part of the respondent to meet his own litigation expenses, usually the husband. And thirdly, an inability to meet her or his litigation expenses from their own assets or resources, usually the wife. But what he has to say is well worth a read, and it's quite clear. Even though the wife went from 1 to 5 on the appeal, the door's not shut. Just because you sort of had one shot doesn't mean you can't come back and ask for another piece of the action, so to speak. But it's interesting in the way that a cost order can be found upon section 74 is using the spousal maintenance tab. Section 117.2 using the cost tab, or section 81H is the power of the court in exercising its jurisdiction under section 79, and there are slightly different nuances in relation to crossing the hurdles to achieve what you want to achieve. And I suppose the section 117.2, and this is the last one I'll say anything about, requires a bit more attention in relation to, apart from the contribution-based factors that go into the mixing the court, making a decision as to it being proper to make the order. You have to detail the cost, the outgoing, some detail. Oh. I might type an answer. We sort of get a lifeline on that one.
Thank you. One stylish slip of pen for you.
Now,
when Trent Waller was president, he was going to do stylish slip of ties, but some of us on the committee suggested pens were perhaps better as an option. Two small slip of plugs for you before you're allowed to attack the alcohol. We're having an event to welcome Judge Baxter on the 18th of June. Please come. Second thing is residential this year, 16th, 17th, 18th, I think of July, am I right, Claire? And I'd just like to highlight that the Thursday night this year, we've tried to rework the program a bit, and we've got a bit of a showstopper. There's a great debate on the Thursday night involving some well-known family law personalities debating a topic around will there be jobs for us in a few years' time. And I think, and I hope, it will be one of the more entertaining starts to the conference. So for those of you coming down, if you can drag yourself down there on the Thursday night, I think it'll be a really good evening. It's the 30th year celebration of that conference, so there will be dancing. And there will be parties, and there'll be very good conference stuff as well, I'm sure. Priority. Can't disclose that. And three flip of hugs, I apologise. Third one, I'm filming tomorrow a video for the residential, and I'm almost full, but I have some last minute places. Those of you that are located close to the court, barristers, we're filming quite close to the court, and it'd be great if you could wander over, Mr. Emerson, because your office is quite close. Well, Ms. Stewart, you have breaks. I've seen you people. I only need you for 5 minutes. So if you've got 5 minutes tomorrow, sort of around lunchtime and afterwards, I've got about 5 more places to fill, and I'd love to have you there. Thanks very much. Go and enjoy. Thank you, guys.